people say, I didn't know you were a lawyer, you don't act like one, you don't look like one, and you say, thank you. So everyone came here to hear about, breach notification laws and what's going on in that area. In my experience, talking to CSOs, CISOs, security managers, whatever, this seems to be the #1 area that just freaks them out. Because the worst thing that can happen is not the breach, but having to publicly tell everyone, about your breach. Okay, so I'm going to start this off with a little vignette, and I'm going to read it to you. I shouldn't read slides, but I'm going to read it to you. You're a CIO, you're at a company where you run an e-commerce site, and you collect it all. You collect names, addresses, credit cards, for some reason social security numbers, and your customers are just located in every state. Your IT department just came to your office to tell you that because of a SQL injection attack, all that information is now out. They almost certainly grabbed all our publicly, our PII type information. Now what are you worried about, besides firing your developers? Okay? If you're saying to yourself, oh crap, do I have to report this as a breach notification, then now you're thinking along the lines of a lot of other CIOs, CISOs, and so on. Okay. So let's keep this little vignette in mind, that you've got customers where personal information was breached and they're in every single state. All right? We're going to come back to that story a couple of different ways.
Hey, Glen, just a quick question.
Yes,
just because you're hacked, does that mean your data was breached? I mean, when you have to prove somehow that data was taken?
Yeah, Gary's question is just because you're hacked and you have an e-commerce site, do you have to notify? And the answer is no. But the answer will vary in its detail from state to state, from reg to reg. But as a general rule, there has to be some sort of reasonable belief, reasonable risk that the breach will result in some harm, identity theft, fraud, something illegal. That's generally a trigger, and I'm going to get back to talking about things that trigger the need to do breach notification. I have another question. What's the proper role of government to oversee breach notification? Any ideas? Okay, and I'm thinking about this in terms of, is the proper role one that says to the company, you have to notify your breached customers and the the consumer reporting agencies? That's one thing that a government organization can do, or it can get very prescriptive, like you see with the government's not PCI, but PCI type prescriptive measures. Okay, so and that's a legitimate conversation and debate to have.
It could also go as far as saying that they're doing it right or they're doing it wrong. What they're putting out, or even if they're lying to the customers when doing it.
The companies themselves?
Yes.
Yeah.
Well, in the government, from my understanding, if the company was grossly negligent, the government, especially like the FCC and stuff, impose
right. There's all
punishment or penalization, or
right.
They might have to reconstitute in some way.
Right. What's your first name again?
Tim.
Tim. All right. Yeah. Tim makes a good point that says, that the role of the government can be to point out some gross negligence. And the thing that's different about breach notification, and it's a relatively young area of the law, is you always had a legal right to bring some sort of action against a company for screwing up your personal information. You can look back in the 60s and 70s, and there's always privacy protections, but you had to be the one, or unless there were like 10,000 of you in a class action lawsuit, but you had to be the one to initiate the action against the company. And This turn of events, primarily because of identity theft and the rage that that's become, this turn of events puts the onus on the company that says, oh, yeah, we were breached. We disclosed to the public, to oversight agencies that we were negligent, basically. Okay, that's the big turn in this sort of notification. So the topics I was going to kick around tonight with you guys, make it as interactive as you care, is talking about where we are today and how did we get there in terms of the state-based legislation. If you're involved in a breach, there's a pretty good chance that a class action suit will follow depending on the size and scope of the breach. Where we are in terms of a national standard around breach notification, the first line would say there's 46 states that all have different kinds of laws. I'm going to touch on that in a bit. So the thing in Congress at the federal level is, do we need a national standard to pull in the provisions of all these different state regs? And then we'll have some fun with the politics of the situation and where this might go. Okay. So before even considering any specific laws around breach notification, as Tim pointed out, you can always have a legal action for bringing some sort of case against a bad actor, a bad company. Okay? So much of this breach notification finds its roots in negligence and privacy law. And the way negligence and privacy law always worked was, you as a company, say you're a financial services company, and people are sharing with you their social security number, private information, and so on, that puts on you a duty to care for that information. If that duty to care is violated, resulting in some harm to the clients, then you potentially have a legal action here. And as I just mentioned with Tim's question, because of the increase in identity theft cases, I think there was, I read like 9 million in the last year alone in the United States, we see this notion of the burden being on the victims to the burden being on the company by legislation, by some political action. The most common way that this took form legally, in the past few years, it's changed. Let's go back about 5, 6, 7 years, way back in the dark ages. It was common to see class action lawsuits for this type of privacy violation. I'm going to cite the Ameritrade case here. I don't know all the details about it, but I'm doing it for illustrative purposes. There was a class action suit brought against them because 6 million client records were exposed through a computer breach. And after some amount of evidence presented at trial, there was a judgment of a little bit over $2 million for the plaintiffs. And this is kind of what bothers me a little bit about class action suits.
Well, I'll take my 25 cents.
Yeah, of the $2 million,
The lawyers get paid first.
the lawyers got paid about $1.9 million of that. And what's the correct due for the victims here? See, 25 cents? Do I hear anything else? How about a year of antivirus software?
Great, McAfee.
Free! Well, the company had to pay for it out of the settlement.
They got
But as the victim, that's what you got. So, sadly, that's the course that class action suits will take. It's important to bring it up in the context of this discussion, because if there's a breach lawsuit in play, even though the state attorney general might bring some action against the company, you can almost always count on a class action suit accompanying that. So don't let stuff out of your networks.
So do they get free software or linked to the download of the free version?
I don't know. All right. So let's enter the idea of state-based breach notification laws. The first that we saw was in 2003 out of California. These two fine gentlemen up there, Gray Davis, it was introduced under his governorship, and basically Arnold had the privilege of seeing most of the cases under it. But what
He
happened?
could have saved himself if he just injected a few fines into that law.
This legislation came about because there was a government agency, there was a break-in, personal information was, exposed to the bad guys. So California decides we've got to do something about this. They come up with a state-based law that basically became the model for a lot of other state laws. If the company is breached and personal information is released of a California resident, then and the personal information was the name plus one of social security number, driver's license, or financial account number, and it wasn't encrypted. There's this idea of not being encrypted. You're going to see this idea called safe harbor, basically exceptions to the general rule. Then you had, as a company, you had an obligation to report this breach to your victims, your client victims, as well as the appropriate state-based agencies, consumer protection agencies. Okay. Later on, they expanded it to include health and medical. Yes?
That does bring up an interesting issue. How much encryption are they necessarily requiring?
That depends.
Because if they're requiring a shift, then, it's not going to be very effective.
Well, when California's was put out, it just said encrypted data, and then you see other states start to follow suit. The most aggressive that we saw was Massachusetts saying 128-bit encryption, period, or greater. And as you start to get very prescriptive about things you got to do, that gets into a whole another area of, do you want your government prescribing your controls?
Well, and that also becomes a problem, because if all they're doing is literally a shift register, then there is no encryption in there.
Right. Well,
So a minimum is one thing, but
Right.
they should never be prescribing necessarily a maximum.
For the most part, what they'll do now is they'll say industry standard encryption schemes or redacted numbers will also find its way into that safe harbor as well. But the first case that we really saw being pursued under the California law was ChoicePoint. And I think you've probably had other people up here talking about all the ChoicePoint stuff, so I'm not going to get into the details or the technology behind what happened there. But from an interesting legal standpoint, ChoicePoint did everything that the law prescribed that they ought to do, and that was their mistake. What ChoicePoint did was they said, well, we had a breach. Let's get the police involved. Let's do the right thing. Oh, we have this California statute. We've got to deal with 35,000 California residents. All right, let's tell them that their information may have been potentially breached. Well, and then they stopped because there was no other legal obligations on them. People in California don't keep secrets. That got out, the next day. And the attorneys general from 38 other states, media, politicians were, how dare they only inform people from California when people from New Jersey, Ohio, Michigan, my state, I have residents too that were harmed in this. So what the ChoicePoint, the legal precedent that kind of evolved from that case was, even though California was just a state law, it had the impact of being a national law. Because nobody wanted to be the company that only picked and chose, select groups of people, and not their entire database of breached customers. Okay. Since ChoicePoint, since California, everyone else has to have their own state laws too, right? Ohio being no different. But as the states started to release their own versions of breach notification laws, you start to see different variables creep into the picture. Okay, Ohio, for example, puts a 45-day outer limit on the amount of time that you have to notify your breached victims that they've got a problem. In terms of defining personally identifiable information, we pretty much still follow the California standard. That's probably going to be a moving target in the next coming months or years. But the name plus social security number, driver's license, and financial account number is still like the gold standard for PII. Ohio also took on this concept of, and this goes to Gary's question, the company itself that's been breached has the obligation to determine the potential harm from that breach. So a material risk of identity theft or fraud, as determined by the company that got breached, is the standard in Ohio and in many other states. Okay? When we get into the stuff that Congress is doing shortly, you'll see that's also a moving target. We also start to carve out exemptions for companies regulated by HIPAA, by GLB, that have similar provisions. Not exactly the same provisions, but similar provisions. And then, again, we take the encrypted or redacted data as an exemption as well. Now, you probably can't read that from the whole room. Ray?
Does Ohio's law cover paper?
Oh, does it cover paper? Ohio.
I know it didn't.
I'm going to say,
I know it didn't initially.
exactly. I'm going to say it probably got amended to include paper, but I don't know the answer for sure. I should have some sites of, there's a website that has all the state laws, just listed, and you can click on every one of them to see what the current provisions are. That'll be a future release of this talk. But I showed this chart here, and it's only got 3 states there, but I'm showing how different states treat different triggers or different definitions differently. Ohio, for example, when you look at this as definition of PII, can anyone read this actually? I can.
Yeah.
Okay. It says, what is PII? In Ohio, we just saw that. Okay. But in North Carolina, they've added things like records containing personal information, but not email, IP addresses, and so on. So it's when you say it's everything except these 5 things, that gets a little bit confusing. Massachusetts defines it just a little bit differently, and they have this interesting kicker in there that says financial account number is with or without PIN information. We don't care if it's got a PIN or if it doesn't have a PIN. If it's out there, it's out there. You got to report it. Period. Notice of the trigger. Again, Gary's point of if and when you have to do it. Time frame. By when do you have to do it? Notice to whom? To your victims, to the state agencies, to the national agencies. Usually that depends on if there's over 1,000 or over 5,000, depending on the state, that it would trigger reporting to a national consumer reporting agency. And then there's safe harbors all over the board. So what we have here is potentially a mess for the guy in our vignette who's got to figure out, now what do I do? All right. Now, as inventive as people in our industry are, I actually found an app, a cloud-based app, and if you've been breached, you go to that site, you put in all your stuff, and they spit out a project plan of...
And one says they have a direct link to PR Wire.
Yeah, that would helpful. That would be helpful.
Well, not if you don't want to release it early.
Right, get it out. But it's like, okay, if you have clients in North Carolina, you better do it right now. If you have clients in Ohio, you can wait 2 weeks. If you have, but again, I go back to the tough rule that Choice Point learned of, don't mess around with treating different states differently. Okay. So in addition to the patchwork of state laws that govern this stuff, it's kind of unique to the states to introduce regulations by industry, some of which cover breach notifications. HIPAA, GLB, to some extent cover breach notifications. I'm not an expert on that by any stretch, so don't ask me any questions about where HIPAA and GLB come in terms of breach notifications. But I do know that the Obama administration is getting a lot more aggressive about enforcing fines and being aggressive about letting any of this, especially health information out right now. It's a big political thing. So, finally get to our heroes of the day, the U.S. Congress. They're going to solve this all, right? Congress has been trying to pass standardized breach notification laws for the past 4 Congresses. That means for the past 8 years. Okay. Last year they came the closest. The House actually passed, went through committee, onto the House floor, passed the House floor, kicked it over to the Senate. Senate decided not to look at it, so it just died. Okay, so of course in the current Congress, the 112th Congress, there are 4 bills alive right now. And Ray, when we did this talk like a month ago, this is even different now. So it's definitely fluid. I was going to spend a little bit of time, talking through how this stuff becomes law. You've heard the phrase, no one should actually see sausage being made or laws.
Yeah.
I'm going to give you a little glimpse into the law part tonight. Maybe at ISS we'll do the sausage part. But, so we've got, and I've spent some time studying this one, but it's really, really, really similar in scope to the other ones. So chances are what that means is at some point, if it gets to a House floor vote, I think it's going to get onto the House floor before the Senate will hear it. At that point, they'll probably merge most of these provisions. But I wanted to share what's going on with this stuff. When laws when they go through their cycle, okay, so Mary Bonomack, for example, this is one of her pet projects. She's going to push this breach notification stuff through. So she's chairing a committee on the House that the first thing they're going to do is interview witnesses. And I've got a treat for you tonight. One of the witnesses that she interviewed was the president of Sony, who got breached, the legal counsel at Epsilon, and then a bunch of others. But I thought I would share this. Hackers generally don't get to appear at congressional hearings and tell their side of the story. They get to use the internet, their websites, or whatever to get their stuff out.
Oh, so they're on channels we actually watch.
Yeah. I mean, so you're far more likely to see their version of it than C-SPAN. That channel that you keep channel surfing right over. Lest you fall asleep. Just to tell you what kind of an effort I put in here, I've watched 6 hours of C-SPAN to do this.
Oh, come on, you built an app for that.
There's an app for that too. But anyway, this is, the was Glen Security that was, allegedly behind the Sony breaches, writing that this was the simplest of SQL injections. We got everything. It was easy. Nothing was encrypted. It was a piece of cake. Well, that's one side of the story. I'm going to give you the other side of the story too. And hopefully we have good sound here.
These disturbing data breaches. I'm confident that the lessons learned will assist us in our efforts to develop new online safeguards for American consumers. I'm going to recognize myself for the first 5 minutes of questioning. And Mr. Schaaf, given the extreme makeover of Sony's online security protocols, it does beg the question, why weren't many of these safeguards, such as having a chief security information officer, in place before the April data breaches?
We believed that the security that we had in place was very, very strong, and we felt that we were in good shape.
What? Wait a minute, that's different than that. Okay.
At least he can run away from the problem.
It's called multi-million-dollar company doesn't care.
Hell, he looks like he's asleep already.
Hang on. Let's try you again.
protect themselves from cyber criminals. Thank you very much.
Hang on.
Thank you, Mr. Schaaf, and I'd like to thank both of you for your opening statements as well as for your unique insight into these disturbing data breaches. I'm confident that the lessons learned will assist us in our efforts to develop new online safeguards for American consumers.
Remember, this is how laws are
I'm going
made.
to recognize myself for the first 5 minutes of questioning. And Mr. Schaaf, given the extreme makeover of Sony's online security protocols, it does beg the question, why weren't many of these safeguards, such as having a chief security information officer, in place before the April data breaches?
We believed that the security that we had in place was very, very strong, and we felt that we were in good shape. However, as the attacks indicated, the intensity and sophistication of the hack was such that even despite those best measures that we had taken, it was not sufficient. And as we recognize moving forward that the scrutiny that we're likely to be under from the hackers will continue, we've made additional commitments to enhance the security of our networks. In addition, we had been working for some months now, more than 18 months, to expand both the capacity and security of our network. We're a new business, but we're a very fast-growing business.
All right, let me jump ahead.
Sure.
You indicated, or Sony, in the May 3rd letter that you contacted the FBI on April 22nd, which was 2 days after it determined the breach had in fact occurred. Why did Sony wait 2 days to notify law
2 days.
enforcement?
My understanding is that we notified them as soon as we had something clear that we could report that indicated some sign of external intrusion that would be unauthorized or illegal.
Your testimony indicates 4 servers were taken offline on April 19th before you pulled the plug on all 130 servers. Can you tell us what information was different that was stored on those initial 4 servers?
Well, these were part of a larger network of machines, and we believe this was just the first entry point that the hacker may have used to get into the network. And upon discovering them, we immediately shut them down. But there were other servers that were also attacked by the hackers as well.
Some media reports indicate Sony's servers may not have had up-to-date patches or firewalls prior to the attack. Is that true?
That's actually patently false. The Apache servers were fully up-to-date, fully patched, and in fact, we had several layers of firewalls in place, also contrary to many of the things that you may have read on the internet. As you know, the internet is not always a reliable source of actual information.
Nor is Sony.
And you state that you believe the cyber attack on Sony was unprecedented in both size and scope. Can you explain why you believe it is unprecedented?
Well, we believe that the sophistication of the attack, the collection of activities that were undertaken, the period of time in which the hackers were carefully exploring the network, and then ultimately the scope of the service that was breached makes it quite a remarkable attack. And despite the deep security measures that we had taken, it was nevertheless insufficient to guard against these attacks.
Was the consumer data you held encrypted, and why or why not?
So, of course, the credit card information that was held was encrypted. Password login data was protected using cryptographic hash functions, and these practices are in line with industry practice.
Thank you. Ms. Fitzgerald, would greater security requirements have prevented your breach? And if not, what added protection are your new security measures providing?
At the time, we had very extensive
This is the,
security, as I noted
Tuxalon
in my opening statement
witness.
and the written statement I
This stops
provided.
right now.
We've continued through the investigation to evaluate additional things that may be done to strengthen both our networks and any of the access points. We have also decided to hire some outside experts to even evaluate the network further and see if there's anything else in different parts of our network that need to be adjusted.
Okay. So that's part of the process that goes into interviewing, witnesses in industry that were, involved in these sorts of things. The politics of this, Tim.
Well, I was thinking one of the big problems with this scenario is I wouldn't expect the House representatives to be extremely familiar with technological concepts. They should have, professional, whiteheads, ethical hackers there
Translators.
to tell them and analyze the situation, because all you got there is, our company is trying to protect our butts, so of course we're going to say what we need to protect ourselves. So why don't they have like professional witnesses who would be industry leaders in the field?
They do interview some of those as
The
well.
idea that the president even knew what he was saying is
Suspect to begin
Yeah.
with. Okay. So, I mean, to me, the moral of the story is you see these provisions in high tech, in GLB, in whatever. I'm going to show you some provisions that tend to be very prescriptive for breach notification. Why is that in there? And it's this sort of interaction between Congress people and witnesses,
two people that don't know what the hell they're talking
basically
about.
two people that don't know what they're talking about, creating laws that you and I have to deal with. Okay? So I'm going to show you a couple of more clips. These are just like 1 or 2 minutes apiece. But what I wanted to show you was that when the Congress people start to talk about provisions that should go in breach notification, it becomes very political. In some of these clips, you can see the R and the D for Republican, Democrat, but you can pretty much tell which side they're on. And I didn't realize how political breach notification could be, but now I do. You have issues like definition of PII. Well, the conservatives, the Republicans, you kind of put in the pro-business camp, and they want to limit it, to the standard that's out there right now. Whereas the pro-consumer, Democrat, liberal types want to expand that definition through the FTC. Okay, triggers for standards. Obviously, the Republicans would say we should have a very high standard and let the companies decide, and they're the bosses. Let them decide. And the FTC, Democrats, liberals would say, no, FTC should really be making those calls. So you go right on down the list of those provisions that are typically in breach notification laws. Time frame, should it be longer, should it be shorter? Data minimization is something that none of the state laws really have right now, but that's the idea of the government telling you, you can't keep personal records for 20 years. So, it's my property. I worked hard to get that
Unfortunately, with
stuff.
some of the laws coming into effect, they're supposed to keep information for longer than they currently are.
Right, so there's all sorts of competing interests for this stuff, not to mention, preemption of state law, that's a big deal. I mean, that's in large part why you haven't seen a federal standard, because a lot of state attorneys general would say, you can't trump our state laws. It's stronger right now than you're proposing, so that's an issue of federalism. I'm going to move on. We're just going to, how are we on time, Tyler? Do we have 10 more minutes? Okay. Here's a congressperson questioning a representative from the FTC on just the definition of personally identifiable information.
Trade Commission has the authority to change the very fundamental definition of personally identifiable information. So this gives you this broad latitude. I think a lot of us are a little concerned about. Do you think there's an opportunity where the Federal Trade Commission, under any circumstances, would trigger the need for them to alter, to update, to change that basic definition, how it's currently drafted in the bill now? Because you've got this definition that people understand in the bill, yet you have the authority to change it. Under what circumstances would you change it, and perhaps you could explain what would cause it?
You can tell this is the Republican.
One circumstance that could arise is there could be changes in technology that could require additional information being
But isn't
needed.
personal
but let me
identifiable information pretty much
Well,
technology
certainly-
neutral because it represents an understanding of the privacy of the individual?
I think the precise scope may be hard to define, but what the Commission is absolutely willing to work with the committee to come up with a definition that would meet everyone's and satisfy everyone's concerns. The current definition, we believe, is too narrow. We also believe that the rulemaking that's provided is too limited. I will say that the rulemaking process that the Commission employs is a process by which we do seek input from stakeholders, and we believe that through that rulemaking process, we would be able to address any need for change, but at the same time taking into account any concerns that you and others may have, Congressman.
Well, I think that's what probably, if I was in industry, I'd be concerned that the government and Congress is turning over this power to you, and you might make these changes without a comment period. There might be changes that would affect a business that would make it much more difficult. Let me go on to my second question.
Okay, note to Congressman, FTC already does this through other provisions, but some of these get a little bit contentious between the witnesses and the Congress people. Did you have a question?
Well, one question I have, and I noticed I wasn't asked, is they don't list like the date of birth. And if somebody has your date of birth and your social security number, that would be incredibly simple for if they didn't have.
Or for that matter, fingerprint or iris identification.
You know what, and I thought about that.
What was the question?
But,
Like I noticed that they don't list like for, stand up.
yeah.
They don't list the date of birth if they have your name or social security number and account information. How could they not have the date of birth?
Well, okay, how could they not have the date of birth was the question and other information?
That under,
I thought about that
Date of birth is
question.
Public record and
Yeah.
answer to that.
like, yeah.
Yeah, everyone puts it on Facebook, so it's probably already considered public now.
Yeah.
Almost all of the provisions of these statutes create an exemption for publicly available information. Now, there's a flip side to that, okay? Because a lot of the information brokers that have basically pieced together public information from different sources, making it more valuable than the sum of the parts, are really under fire. Like the epsilons, it's kind of the epsilon provision, are really under fire for tighter breach controls, than normal companies. Okay, is that right? I don't know. I have thought about it in these terms, though. There's a lot of information that you can classify as PII, like date of birth and Facebook account, or whatever. What are the chances that that leads to identity theft and fraud?
But at the same time, say mother's maiden name. I notice there's an exemption for the
No.
parents.
Yeah, but again, that goes. Right now, different states treat that differently, and
Well, at the moment, that's only valuable if the person actually answers those questions accurately.
true.
Yeah.
Question in the back.
At DEF CON, they were doing a social, trying to get information socially,
Mhm.
and they had a contest at DEF CON. They had 20 minutes, and the gentleman that was able to get, he had certain targets in order to obtain.
Right.
The one that I was hearing on the radio, what they said was, and this was during DEF CON, this is like dissimilar information. He had indicated before he even made the call, he pulled as much information he could from wherever about who he was going to be talking to at a company in order to be able to get information to do a breach.
Exactly.
So that's the dissimilar information that you're
Right.
talking about. He got it socially, and what was interesting at DEF CON, when he was done, it was reported that he was offered a job.
Great. I've seen one of the provisions of the federal bills really hold information brokers that hold, if there's a certain number of records, let's say it's 10,000, but that's not the right number. If you have that many records with the dissimilar information as you described, part of the prescriptive nature of the bill is you have to submit a security policy plan to the FTC to keep doing it. Like, wow, you have to submit your policy to the FTC to be an information broker.
That's in one of the bills?
I'm sorry? Yeah,
But
it
it's
is.
not currently law.
It's not currently law.
I have a quick question. What do they classify as publicly available information? For instance, I could go on like LexisNexis or Telly's and get background information on just about anybody.
Right.
But if that information is in a breach, is that classified as they would have to notify you?
Right now, the standard is if the company is holding it, social security number, driver's license, credit card number, plus first name, last name, or first initial, last name. If the company lets that out, that's considered a breach of personal information, and that's all that's considered a breach of personal information right now in most states. If you can find it on Lexis, if you can find driver's license or social security numbers on LexisNexis, I'm not saying that you can't. That doesn't excuse a company from liability should they release that information. I'm going to try to fly through a couple of these. I just want to give you a sense of this. This is, Gary left us, but he was talking about what should the standards be for when a company has to do a notification. I'm only going to give you the first couple minutes, or the first minute or so.
Thank you for your time today. As you know, the Safe Data Act would require an entity to begin to notify as promptly as possible, and that's a quote, individuals whose personal information was acquired or assessed in a breach following an assessment, and the notification should be based on risk of harm, not just on the fact that a breach had occurred. Otherwise, we may find ourselves in a situation where consumers are flooded with notices by companies, become desensitized, and then may not take action to protect themselves when there is a real risk due to a significant breach where personal identifiable information was stolen. Identity theft could occur. As currently drafted, this legislation standard for risk is, quote, reasonable risk of harm. In response to my colleague, Congressman Stern's questions, you said that that is the standard that the FTC supports. Do you think consumers would be better served in the long run if the standard were changed to, quote, significant risk of harm, end quote? And what, in your opinion, is the difference between a reasonable risk of harm and a significant risk of harm?
I don't think that consumers would be better served if the standard were to be elevated to a significant risk.
Of course you don't. You're the FTC. Okay? But again, that gets a little more contentious too. But the issue there was the Republican congressman saying the standard by which companies should be forced to report that breach should be company determines a higher risk of harm rather than a risk of significant harm rather than reasonable harm. I don't know what the difference is. They don't either. But it's just a matter of higher levels of when you have to report or lower levels of when you have to report. The Democrats will say lower levels and let the FTC do it. The conservatives will say higher levels and let the company decide. This is where this is a Democrat from Illinois, Jan Schakowsky. Listen to this.
The Safe Data Act required notice to the FTC and consumers of an electronic data breach only if the covered person has determined that the breach, quote, presents a reasonable risk of identity theft, fraud, or other unlawful conduct. I know that others have asked this, but I wonder if one more time. Do you believe this trigger for notification based on reasonable risk, et cetera, is appropriate?
Reasonable risk
I
is
do.
the current
I think that the standard of reasonable risk gives it appropriate flexibility and to accommodate both the need to protect consumers as well as the need to take into account any burdens, excessive burdens on business.
And pay attention to where she takes this.
A covered person to determine whether or not the trigger has been, for notification to the FTC and consumers has been met. Do you believe it is appropriate for the covered person to make the ultimate determination about the risk posed to consumers from a data breach and whether notice to the FTC and consumers is required? And if not, who should make that determination and how should they go about doing that?
That's a serious concern that we have.
Of course it is. Okay, the serious concern that they have is they want the FTC to be able to make the call when a company has to report a breach. If a breach has been discovered, tell the FTC, tell the federal, basically the FBI, but tell the FTC, and the FTC will tell you whether or not you have to report that to everybody, basically to your customers and the media. Okay? These are the kind of contentious exchanges that go on that for years have really held up this sort of legislation from basically coming out as a federal standard. Waxman here is basically going to say that the time frame by which companies need to report breaches needs to be shorter rather than longer. Okay? So we're not going to spend any time there. And I'm going to kind of leave it with this. The one thing that none of these debates considered was, and all this language is sort of couched up front in the bill, none of this is debated, Republican or Democrat, that companies should now have, that store personally identifiable information, should have a written security policy, identify a security officer, have a program for identifying, assessing, and monitoring vulnerabilities. I promise I do not have a lobbyist in Washington as Hurricane Labs. But these are very prescriptive things that basically has the federal government through the FTC telling people what to do with regard to their security controls. I totally see this as becoming the PCI of federal breach notification.
I was just saying, the first three seems, I can't believe that they don't exist.
Look at RSA, they didn't have a chief security officer until they got beat up. How could that possibly?
Well, whether or not it's a good idea that it exists is one question, but whether or not the federal government can tell you that it has to exist is another. Sure? Okay. So, in the Obama proposal, it gets quite aggressive, but I'm going to just leave that at that. So what's probably going to happen? The Obama proposal says everything's personally identifiable information. You know, deal with
Well,
it.
conceivably, if you can talk to the person, anything can become personally identifiable information.
But I never hear it's personally identifiable and if let out could lead to identity theft. Because that's really the standard that they're trying to solve here. And I think they don't do a very good job of honing in on that very issue. What do I think is going to happen? For continued confusion over the different state laws, there's going to be more breaches. That's just inevitable. We'll probably, I suspect, we'll probably see a version real close to what's in the House right now. It might get a little bit watered down because I think basically the companies have a little better lobbying group than the consumer groups, but a little bit. I think inevitably it's going to be another national standard. All right, so that's just me. Now, Greg, you have any other questions?
Is that personally identifying information?
You tell me.
Obama thinks it is.
You tell me. Yeah, it is. Go ahead and that's me. All right, you have prizes?
Yeah.
Okay. Remember Mary Bonomac, our heroine in the whole grilling the Epsilon and Sony people? Okay, so the first question is, remember that smirk? What does she have in common with Cher?
Married. Yeah.
Married to Sonny.
They were both married to Sonny at one point.
Is that why they both?
Well, there are only some states you can do that in.
Now you're showing your side as a lawyer.
All right, and in what city was she born?
Denver.
This is a layup.
Cleveland?
I need to see a hand first. Yeah, she's a Clevelander. She went to Palm Springs with Sonny. She took over his house seat after he passed. So that's all I got. Take a break.
So we're going to take a quick 10-minute break, and then we'll have Lester come up and